All right, welcome everyone to our Music Royalties 101 live webinar hosted by the Copyright Alliance and with Music Law Pro today. We're really excited to have our speakers today speak to this audience about music royalties, what they are, what kinds there are, and, how you can think about this topic, from the perspective, of yourself as a music creator. So again, welcome. Again, I am Rachel from the Copyright Alliance and Copyright Council here. And I just wanted to, before we kick off, just put a plug in for our individual creator membership. So you can stay tuned to events like this webinar in the future and other educational resources that you can take advantage of and learn more about how copyright law affects you as a creator. So you can go to copyrightalliance.org to sign up for our individual creator membership for free. If you go there, go to the top of the web page, there's an orange Join Now button, so you can stay on top of all the copyright law issues and take advantage of really great webinars like this one. So without further ado, I'll just make some introductions to our speakers today. And, our speakers, Jesse and Alexandra, they come from the Music Law Pro law firm based out of Southern California, where they provide a lot of different kind of fixed fee and subscription-based services to cater to all of your music law needs. And so to learn more about sort of their services and for more information, you can go to musiclawpro.com. And then I'll introduce Jesse and Alexandra themselves. So Jesse Morris is the owner of the LA-based music law firm, Morris Music Law PC, where he primarily represents songwriters, artists, producers, managers, labels, publishers, and music-related tech companies. Additionally, Jesse is the founder of Music Law Pro, where he manages and oversees all other attorneys and staff. He is a musician and composer of music himself and has been in several rock acts. Jesse was a co-chair of the LA chapter of the Copyright Society, and he's spoken at events for UCLA, USC, the Association of Independent Music Publishers, California Lawyers for the Arts, Digital Entertainment World, South by Southwest, and the Beverly Hills Bar Association. So thanks so much for your time, Jesse. And we're really excited to have you as a speaker today. And then next, we also have Alexandra Mayo. Alexandra Mayo is an associate attorney with the Morris Music Law PC and Music Law Pro. She is a singer, pianist, and dancer, and her love of music and performance has been a constant in her life. Alexandra earned a BS summa cum laude in the performing and allied entertainment industries from the Bandier program at Syracuse University and a JD with a media and entertainment law certificate from the University of Southern California. Alexandra has spoken at events for JSM for Artists, USC, Loyola, and San Jose State University. In addition, she sits on the board of directors for the nonprofit organization, the National Women of Color Collective. So welcome, Jesse and Alexandra. And again, thank you so much for your time. And we're really excited to have our creators learn more about Music Royalties 101. And before I turn it over to you all, I just wanted to provide some housekeeping, matters. So if you have a question for Jesse and Alexandra, they'll be taking them throughout the presentation as they are able to, and then address a couple at the end as well. And we encourage you to send these questions their way through the Q&A function in this Zoom webinar. So without further ado, I'll turn things over to Jesse and Alexandra.
Yes, thank you so much, Rachel. Very excited to be here today and to be able to just tell everyone about music royalties and just really make sure that you have a little bit more knowledge here moving forward. So we went through a little bit of an introduction for who we are, but we're going to provide a bit more information. While we are also introducing ourselves, we would love to know who you all are as well. So feel free to drop it in the chat or the Q&A function if needed, but just let us know, who are you? Are you an artist, a label, a producer, a manager? All of those things are helpful to know just so we can know, how royalties flow. How you're doing things depends on just who you are. And we just like to know these things to make sure that everything is relevant. So while we are doing that and while you're introducing yourselves, again, a little bit about us. Rachel gave a great introduction. We offer subscription and membership-based services and fixed rate-based services. We have a few different options because our goal is really just to make sure that we are able to provide legal advice at a rate that people can afford. We don't want a situation where you're too scared to talk to a lawyer just because you think that you can't afford it or because you think that they are just way too expensive or way too stuffy. We want to make sure that you're actually able to get that advice. So we offer different membership models and different pricing tiers to make sure that it can be affordable and that you actually have advice and that you're really protected moving forward. We have different membership tiers that include certain things. Some include unlimited advice, some include copyright registrations or contract review. Other times we have just fixed rate services. If you're interested, talk to us, hit us up. You can find us at musiclawpro.com or hello@musiclawpro.com. We want to be able to talk to you and really provide service and advice for you.
Thanks. I'm going to jump in. Thank you
Yes.
so much. I love the posting, the Q&A. We don't have a chat, so we're rocking the Q&A today. If we were in person, we would like raise your hand if you're a musician or an executive. So it really looks like we have a broad spectrum of people here. I'm going to apologize in advance if some things are really basic. We wanted to just keep it simple, but we'll try to flesh things out as we go along too. If things are too complicated or too simple, let us know. And I really like the interactive. As much as we can, be posted in the Q&A. We're going to try to monitor it as much as we can. And it's really awesome. Like we see there's composers, there's musicians, there's BMI, there's attorneys. This is a great audience. I'm excited. So we can get a nice little spectrum of audience and try to provide really useful information and have some really good takeaways coming out of this. There's going to be a lot of info, but I want to really provide some useful, helpful info for everybody. So, you know, as we go along with questions, if we could kind of make them relevant to everybody, if possible, and have them be questions, not comments, so that's where we're going to try to answer as best as we can. So if it's a specific issue, you know, contact us so we can get into the facts and what's going on in your case. Right now, any questions that could be relevant to everybody is what's helpful so that we're all being entertained and having fun and learning here. Back over, Alexandra. What's next?
All right. Yes. So we also kind of already went through the agenda, but also just wanted to provide a little overview. We are going to start with the basics because, again, there's a lot of different people here from different areas. Some are beginners, some are more in the industry. So we wanted to make sure that everyone has the basics. So we're going to start with the basics about the law, going to introduce some industry terms so you all know what everything means. And then we'll get more into the specific services and specific examples and just really go through how the money flows from different sources here. So Jesse mentioned that you can drop questions in the Q&A and just make sure that you keep it relevant. Also, though, just want to make it clear that we are not able to provide legal advice right now. So if you do ask a specific question in the chat, again, that's not something we're going to be able to actually respond to. So if you do have a specific question, let us know because we really just need to keep it generalized and broad today.
And we are lawyers, and what we're saying now is not legal advice. So it's informational, general informational advice. And we encourage you, if you have specific legal issues, to get a lawyer who's licensed in your state. We got to say that. That's our disclaimer, everyone. We would be terrible lawyers if we didn't do it. All right, let's go here. Everyone ready? Woo, virtual. Woo. All right. I'll jump off here. So we're just going to do some copyright basics, kind of lay the groundwork for all of our discussion. All the music royalties come from copyright. That's the right of music comes from copyright. So it starts with the Constitution, Article 1, Section 8. So that's where we start with the copyright coming from there. And then if we go into the Copyright Act, 17 USC code, we look at the different subject matter of copyright, and we can look right here. We highlighted 2 musical works and then sound recordings. So, you know, there's movies, there's books, there's paintings. What we're talking about here are musical works, music and lyrics, and sound recordings. So it's super, super important. You know, where it's starting with the Constitution and then the Copyright Act. And now we know that there's compositions and sound recordings. All right, what's next? So, a composition copyright, what's that? So that's music, lyrics, arrangement, who's involved, who owns the composition copyright. We're talking about songwriters and publishers. Producers are in there. Anyone who's writing the music, either the composer, lyricist, and then publishers are owning and controlling the composition side. And then on the sound recording side, we have performance and productions. We have artists, we have producers, engineers, mixers, people involved in actually recording the songs, and the performances of them, and who's involved, who owns, our artists and labels. So when we're talking about songwriters and publishers, we're dealing with the composition copyright. When we're talking about artists and labels, we're dealing with the sound recording copyright. And things get blurred because in each recording, there is the underlying song. But when we're talking about the flow of money, how royalties and rights work in the music industry, it's super important to understand this distinction. And if you're a beginner and you get any takeaway after this whole hour webinar, staring at the screen, is understanding this distinction really, really helps and will help you understand more than 99% of the people in this world about how music royalties work.
I think also a good way of thinking about this is by thinking of it by way of example. So the example I always like to give is the song "I Will Always Love You." That was, for the sake of this example, I'm assuming like one person wrote it. So let's say "I Will Always Love You," originally written by Dolly Parton, and Dolly Parton also has a version that she recorded and has released. Great. She owns both copyrights there. She owns the underlying musical composition and she owns the sound recording. And again, for the sake of this example, assuming she owns it, not like a publisher or her label, just assuming it's her, one person. Now, Whitney Houston has a very well-known version of "I Will Always Love You." That's technically a cover, but thinking of her version, the underlying musical composition copyright is still owned by Dolly Parton because she's the one who actually wrote it. She created the music, she wrote the lyrics, but the actual performance of "I Will Always Love You" by Whitney Houston, that sound recording is owned by her. So that's another good way to kind of think about the musical composition copyright and the sound recording copyright. And again, royalties come from both of those different things, and we'll go through kind of how that money flows as well.
Amazing, great work on that example. I use that All Along the Watchtower with Bob Dylan and Jimi Hendrix. And we think of like Jimi Hendrix, and he's playing All Along the Watchtower. It's Jimmy's version, but it's still Bob's song. Someone asked what the P stands for in question. That's phonographic record. These are copyright symbols that you can put upon copyrighted works to show, notice of copyright ownership, along with a year and owner. So that the C is used for the song side and the P is used for the recorded side. So when you go home and you look at the back of your old CDs collecting dust, because who uses CDs anymore? Or even on Spotify, you'll see on the bottom, circle C, circle P. So the P is referring to the recording owner and the C is referring to the song owner. Great question there.
Someone else asked another question, and I think that's a very good transition into our next slide. They asked kind of what holds more protection, the musical composition or the sound recording. There's protections for both, and those are enumerated in 17 USC section 106. Essentially, when you own a copyright, you have the exclusive right to do certain things. And those rights include the right to reproduce it, the right to prepare derivative works, which can be like remixes and things like that. You have the right to distribute it. You have the right to perform your work publicly. You have the right to display the work, all things that you as a copyright owner have the exclusive right to do because you are the owner. Now, the sound recording is a little different, and we'll get into it. The sound recording, you have the right to publicly perform it by digital audio means versus with the composition, bit more broad, just the right to perform it publicly. But again, we'll kind of get into that distinction. But these are the main exclusive rights that come up when we're thinking about copyright. What am I exclusively allowed to do with it? And if someone else is going to use my music, what do they actually need a license for?
Totally. And yeah, notice how in 4 here, it does not have recordings, and in 6 it does. And sadly, the US is in company with like North Korea and China, and that's it. Maybe Iran offhand. And there's been bills in Congress almost every year to expand the public performance right for sound recordings, and it doesn't get passed for a variety of reasons thus far. And we're going to see when we get into specific use cases coming up here, how this actually impacts money. and the flow of money because of this distinction of rights set forth here in the Copyright Act.
Yes. So that takes us to this kind of high level bird's eye view of what these copyrights, how these copyrights relate to money and the royalties here. So on the musical composition side, the main royalties we're going to look at are performance royalties, mechanical royalties, and sync royalties. And on the sound recording side, we're going to look at kind of interactive streaming and what that looks like, non-interactive streaming, and then also master use royalties. And I am going to skip ahead. This is a great visual for how you can actually think about the different royalties and how they break down. And we are going to break this down even more. So the first two columns that you'll see here are just songs and musical works. Oh, and also this came from the MLC. Amazing graphic that they came up with. But the first two columns are really just focused on the song. So that's what we're talking about, our public performance rights. We're talking about the mechanical royalties. And then the second two columns are really for the sound recordings. That's when we're looking at those distribution rights and kind of what's involved there and what money comes in there, both for physical and also for digital. And this really just looks at the digital landscape, but we're also going to talk a little bit about physical here.
And we can see right from the section 106 rights where we have in one here, public performance, and then we have two, reproduction and distribution. So the reproduction distribution rights are mechanical royalties, and that's for the song. So when we're talking about mechanical royalties, we know right away it's the song work and it's for reproductive distribution rights. And then we jump over to 4 and it's like performance rights, digital performance. Oh yeah, that's the sound recordings. They had a limited performance rights. So that's why it's a separate section over there. So yeah, it's a nice graphic from the MLC. I know it's a lot of information here. We're going to be going into specific uses though, specific examples, whether it's FM radio, YouTube, Spotify. We're going to get to it all the best we can here. We're drinking coffee. We're going fast. Hopefully everyone's having fun here. I think there will be access to this presentation afterwards. We're ironing out the details. So yes, what else we got here? We're gonna get into sync stuff in a little bit. Let's hang tight. Arrangement and derivative, that's a great question. A derivative is making a new work based on a prior existing work. Arrangement is using prior existing works and arranging them in a new way that's copyrightable. So an arrangement could be a derivative or not. There's also certain basic rights to make arrangements that are still covers. So it largely depends on how much you arrange, what pre-existing material you are using. Arrangements also generally used more in the song side. You're arranging a song, whereas with a derivative, like for example, in a remix of a recording, maybe the same song, but you're remixing the drum parts or something like that. So they play hand in hand with each other. Let's keep going, Alexander. Let's get into some money here.
Yes, love it. So first thing we're going to look at is AM and FM radio. And really that first little column that we saw on the MLC chart that's talking about public performance and public performance licenses and royalties. So first and foremost, what is a public performance? Think about any time you hear music in public, whether you are in a mall, whether you are at an amusement park, in an elevator, at a concert, at a restaurant or a bar. If you hear that music in public, that's considered a public performance. And anytime you hear that music in public, those people or whoever the venue is or the establishment, they generally have a license for that because you're getting paid for that public performance. Because remember, on the song side, you have the exclusive rights in public performances. So that's where these public performance licenses come into play. And generally, these licenses in the United States are granted by the performance rights organizations. And there are 4 main performance rights organizations. Those are ASCAP, BMI, Global Music Rights, and CSAC. And generally, when a venue needs music or an establishment needs music, they will get a blanket license through the PROs. And like I said, that's Performance Rights Organization. So they will get a blanket license through the PROs, and it essentially, there's different calculations. It just depends on the size of the venue. It depends on what they need the music for, but they're going to get a license from the PRO, and then they have that right to then use the music. And on For the musicians themselves, for the writers, again, this is the song side. So we're thinking about the writers, the composers, the publishers. Generally, the money that comes in and is distributed out is going to be split 50-50. 50% is going to go to the writers on the track. That's known as the writer share. And 50% is going to go to the publishers on the track. That's known as the publisher's share. Before we dive into specifically what that looks like for FM radio, Jesse, did you have anything you wanted to add to just make sure that people really understand public performance here?
Yeah, there's more nuances in public performance. In addition to publicly hearing it, like publicly being performed, there's also a retransmission clause as part of the definition of public performance. So when we get an interactive streaming like Spotify, that's still a public performance. Even when I'm sitting on my computer or my iPhone listening to my Spotify playlist, that's still considered a public performance via the retransmission clause. We'll get into that more when we get into Spotify, but I didn't want everyone to be like, wait, how's it a performance now in Spotify? So that comes into play in different areas. And was going back to FM radio, we started with this one because it's simple enough. We turn on the radio, we hear a song. Now, the radio station has a blanket license with the PROs where they pay a certain amount a year, roughly speaking, to play all the music in their repertoire. And then the PROs have a way to calculate what's being played, either a census or a survey, and different weighting methods. Like if it's at rush hour traffic on prime time, it's worth more than 3 a.m. on some nobody listens to station. So the PROs have their own rules to kind of weight different performances and then pool up all the money they get in their blanket licenses and then pay out half to the publishers, half to the writers. And how much gets paid to the artists here? When a song gets played on FM radio, do the artists, do the labels get paid anything, Alexandra?
No. So it's only on the song side. So again, we're going to keep coming back to this idea of the two copyrights. So we're going to talk about that repeatedly. Here on the song side, great, you're getting paid. You're getting your 50% writer share, 50% publisher share. But unfortunately for the labels and the artists on the master side, nothing comes in for that when we're talking about AM and FM radio at this stage.
All right. Yeah, note as well that the PROs are going to take an admin fee off the top. They're going to take their blanket fees. They're going to pay themselves roughly 10-15%. And it depends on the PRO. ASCAP is nonprofit. The rest are profit now. So that may impact what they're taking on their admin fee, and then they pay out the rest 50-50. And to get paid as a writer and a publisher, you have to register your songs with your PRO. And as a writer, you can only be with one at a time. And then you have a corresponding publisher with whichever PRO you are with. Publishers can be with one or many of them so that they can represent whoever writers are under them in their publishing deals. If you haven't joined yet, ASCAP and BMI are open to everybody. And then Global Music Rights and CSAC are invite only right now. Anything else on FM radio, or can we?
Yeah, no, I think we hit it all. So next up is probably going to be the one that I know there's a lot of interest in, is interactive streaming. Spotify, Apple Music, how do you get paid? What does that actually mean?
All right, so now we open the door to a bunch of different types of royalties. So this graphic is from Manat, a nice little info graphic for us. These are just general numbers to just what happens with a dollar, roughly speaking. So Apple, Spotify take around their 30% cuts, and then around 15%, the numbers are slightly off here, goes to the song side. So that's the bottom of the circle here. And then that's split between mechanical and performance. The mechanical, the MLC is collecting in America, and then the performance, that's where we had the PROs, the ASCAP, BMI, etc. And then the rest of the money goes to the sound recording owner, which would be the label or an artist if they don't have a label. They're a self-released artist. So we can see on Spotify that most of the money is going to the label. And the rationale, this is coming from a world of physical CDs, vinyl, and then downloads. So the recorded side are producing the masters. They're expending the money to make the recordings and to market them. So the rationale is they would get more money with the actual interactive streams. And note, this is an interactive stream. So a user is actually picking, I want to hear the new Taylor Swift song, I'll pick on her, why not? So, so this is not a non-interactive, whereas FM radio is, you're not turning on the radio and picking your song, you're passively listening to FM radio. Whereas with interactive streams like Spotify or Apple Music, you are picking the song. So in a way, you're not downloading it, you're streaming it, and then the money is the Apple, Spotify, they're gonna take their cut, roughly 30%, and then roughly this 50-60% goes to the label artist, and then the rest is going to Performance Mechanical. From the mechanical side, that's all going to the publisher. None of that goes to the writer, the way that Performance did with the PRO side. All of the mechanicals with the MLC goes to the publisher. If it's an artist, writer that they don't have the publisher, they're self-published, they will get their own publishing money. But it goes to a publisher, not the writer, on the mechanical side, whereas the performance gets split, half writer, half publisher. So that's important to note. Let's see, let's go to the next slide and look at kind of 1 million streams, how the money works there. So this is just taking the last slide with the dollar, and all right, actual money. These numbers change. Apple and Spotify play with their algorithms, and there's different deals with the majors, and things adjust based on ad revenue as well. Particularly Spotify, it's not all subscription. So certain ads may generate more money. So these are rough numbers, but this is something Manat put together as well. All right, with 1 million streams, how much, roughly speaking, with Spotify, you get around $4,000 if you own everything. So we kind of look at every 1,000 streams around $4 when we're looking at numbers and trying to calculate maybe damages or worth for a producer deal or a record label advance. How much are we looking at in terms of recoupment? Clearly, Apple makes a bit more because they don't have ad revenue. So it's subscription only. So it looks like you're making a bit more on Apple, which is nice. So these are good. And we can see here the mechanical performance piece of the pie versus the sound recording piece of the pie versus what Spotify and Apple are taking. So it's nice to see how the split of money here when we hit 1 million and some actual dollar numbers. People get excited all the time. They call our office. I got 1 million plays, so I'm gonna retire and quit my day job now. And it's like, awesome job, you got 1 million streams, but there's more work to be done, and you can't quit your day job on $4,000. So these services are constantly looking at revamping how they pay out royalties. There's a discussion of doing user-centric or artist-centric versus the current pro rata model. That's kind of going down a deeper rabbit hole. We can circle back to that as we need be. So yeah, what else on these interactive ones, Alexandra? We got anything else?
Yeah, I think just kind of touching on some of the questions that we've seen in the chat. So these are numbers for the US. So these are strictly US based that we're talking about here. Of course, there's some similarities sometimes depending on where you are, but these examples are US based. And we're going to talk later about some of whether it's a statutory license or not statutory, meaning that it's kind of set by the government. This is not one of those. So the amount that's paid out really just depends. It's very much negotiated. But it tends to be very standard and customary. Like Jesse said, generally like Spotify, Apple, they're taking approximately like 30%. But these aren't things that are statutory.
Except for the MLC side,
yes.
The Copyright Royalty Board helps. When we look at the mechanical piece and what the overall song side does minus what goes to the performance and gets to the mechanical, that can be set statutorily. The sound recorded side is by contract. I'm seeing a comment from Michelle in the Q&A. The MLC does pay to a self-administered songwriter. BMI can also do that, and other PROs. If you're a songwriter, you don't have a publisher, you can be paid the publisher share directly as a writer. It depends on the organization. And the more that we can encourage the flow of money, it's ridiculous if a writer that doesn't have a publisher just leaves half their money on the table. They should be getting their money, and kudos to the MLC for helping that. And what else we got on? Any other good questions? Who decided these percentages? We talked about that a little bit. Spotify is changing their royalty structure now to not pay out on under 1,000 streams in a year. So we'll see how that works. How do we determine what one stream is worth? Spotify takes all their money that came in from subscription and ad revenue, and then they look at all the streams, I guess now over 1,000 streams, and then you divide up and then you pay out. So it's going to depend on the per stream rate will depend upon how much money comes in and how many streams there are in a particular accounting period. So it's constantly in flux and changes. And it also depends on who your record label is and what their agreement is with Spotify and Apple for what their royalty rates are. So roughly speaking, these are rough numbers. Manat came up with these numbers. So they're another law firm. They did an article with Billboard. So we're visual people. We want to throw some visuals at you. So it's not just us talking and looking at our faces the whole time. So that's where these numbers came up. And yes, some pay monthly. Thanks, Jeff. MLC pays monthly. At the PROs will pay typically quarterly, but it depends on if it's a writer, a publisher, or an international payout. Spotify, Apple typically are going to be paying out monthly. What's your distributor, your label may pay you monthly or quarterly, semi-annually. If you're under a label, of course, you have to recoup first. That's a whole nother situation. If you're an artist under a label deal and now label's getting the Spotify money, you have to recoup as an artist. And then on an indie deal, you're typically at a 50% net, give or take. If it's a major label deal as an artist, you're typically at a 12 to 20% rates. If you're on a distribution deal, it's typically more 50 to 90% that the artist is getting, with the distributor taking 50 to 10% off the top for distribution. So what your split is in the end of the day as an artist will depend upon what your label or distribution deal is. The Spotify payout is not arbitrary. They have specific rules. They're going to be paying for the performance rights based on their license with the PROs. So the ASCAP and BMI, et cetera, will license a blanket license to Spotify to perform their music. The mechanical, via the MLC in America and the Copyright Royalty Board will determine those. And then the sound recording piece and what Apple and Spotify take is based on the agreement with the label sound recording owner. If you're self-released, then it's going to be your TuneCore, DistroKid, CD Baby. And what else we got?
Yeah, I think it'd be good to take a moment to kind of take a step back and go back like big picture. Someone requested, can we go back to the Dolly Parton example and see how does this fit in? So I think this would be a good example, a good place to do that. So I'm going to go back one slide so we can kind of see the breakdown on the dollar. Let's go back to our Dolly Parton example to really reinforce this and reinforce the different copyrights. So like we said, Dolly Parton, she owns the musical composition. And for the sake of this example, I'm going to say we're using Whitney Houston's recording. So thinking about Whitney Houston's recording, let's say that her recording was played on Spotify. We're just talking about one stream here. Great. So on the Spotify part here, the gray part at the bottom, the mechanicals and performance, that's for the underlying musical composition. So for the Dolly Parton example, we said Dolly Parton owns the musical composition, so that would go to her as a copyright owner. We said 29.38% cents is kept by Spotify. Great, that's theirs, that's their 30% cut. But then now the blue portion, that direct to sound recording owners, Whitney Houston, if we're using that example, she owns the sound recording. So that 58 cents would go to her. So that's kind of the breakdown here for just the copyright and how that looks like for this interactive streaming with that example that we had already talked about. But
someone asked, if you don't use CD Baby, how do you get your music? How do you get your royalties? You need some distributor to get your music into Spotify and Apple. They don't just take independent music, or a label that has a direct deal with Spotify and Apple to get you, or you can just sell your music on Bandcamp and upload on SoundCloud, and do your thing totally independently, but then you're cutting yourself off from having all the audience that Spotify and Apple have to expose to new music. Okay, let's keep it rolling here. And I love the questions, everybody. This is great. If we haven't answered it, I apologize in advance. We're trying our best here, ping ponging back and forth. We definitely want time after we charge through this to circle back on any questions. And if we don't get to any questions, hit us up afterwards. We can, on email or call so we can kind of work through, make sure that we get questions answered. We're trying to make it as fun and engaging as we possibly can, and we can't get to everybody's possible questions. We're trying our best, and they're great. Please keep the questions coming. It's way more fun to have this be more interactive than just me and Alexander talking the whole time. So non-interactive. All right. What are those, Alexander?
Yes. So now we did interactive. Let's do non-interactive. When we talk about non-interactive, we're talking about streaming services where you now do not have the ability to select your next song. So think about Pandora and SiriusXM are the two biggest ones here. So I mentioned kind of earlier the idea of a statutory license. And like I said, that really just means a license granted by the government where they really set the terms, they set the conditions, and they set the rates. And for non-interactive streaming services, that's what we get. Now this is a statutory license. So these are things that are actually set by the government, and they are handled by an organization called Sound Exchange. So when these services like Pandora and SiriusXM need to get a license to be able to play music on their non-interactive services, they do so through licenses with Sound Exchange. And there are different categories for the licenses and different categories for the services. These are just two of them. So Pandora is what's known as a commercial webcaster, and they are going to be paying out, or their license is going to be based on minimum fees annually, but also kind of per performance. And they're looking at the subscription, what actually is played, versus with SiriusXM, theirs is just a percentage of gross. They are what's known as a pre-existing satellite digital audio radio service. So theirs is going to be 15.5% monthly of gross revenue. These numbers are from 2022. This is something that was the most recent on Sound Exchange's website. But again, as these things change and update, that will be also updated with Sound Exchange because they're the ones that actually handle these statutory licenses. But that's great for the services. What does that look like for you? What does that mean for you on the back end, and how do you actually get paid? When we're talking about Sound Exchange, when I back up, we're talking about the sound recording side of things. So we're back on the sound recording copyright here, and we are looking at, this is a public performance on the sound recording side. We talked about the exclusive licenses, and one of those was the exclusive license to publicly perform your sound recording. This is what we're talking about there. So when monies comes in, it's broken down where 50% goes to the rights owner, 45% goes to the featured artist on the track, and then 5% goes to backing and session musicians through AFM and SAG-AFTRA. So thinking about our example again, let's do Whitney Houston's version of I Will Always Love You. But now let's throw in a record label. So let's say Whitney Houston's record label actually owns the copyright, but she was the featured artist because it's her vocals. Great, her record label would get that 50% as the rights owner. She as the featured artist would get that 45% share. Then any backing session musicians might get that 5%, which is split 2.5 each to AFM and SAG-AFTRA.
And what about the producer, Alexandra? Where are they?
Yeah, so producers are able to get money from the featured artist through what's called a Sound Exchange letter of direction. So it's not something that's automatic. It's not something that they are entitled to, at least for later works and more current works, but it is something that they are able to get from the artist. And they can fill out a letter of direction and submit it to Sound Exchange, and they would get a portion of the artist's 45% share. And generally that's a percentage of net profits that we figure out just based on kind of their agreement with the featured artist, whether it is a net profits percentage basis or whether we're doing a formula based on something else, just trying to figure out what they actually get. But that would be the producers, and also mixers and engineers can get that as well as creative participants.
Yeah, as long as you have a royalty that you're entitled to as a creative participant, such as a producer or an engineer, and you're not part of the artist. And note, it says featured artist, but it's not like Whitney Houston featuring Dolly Parton. It's each of those are considered artists. So from this chart here, we're talking about the actual artist as listed. If we had a featuring, then Sound Exchange will consider both as the artist and split that featured artist share 50-50 unless they agreed otherwise. Someone asked a great question. Can we have an example where there's songwriters and co-writer's a performer, a producer, and a publisher. So that track gets played on Pandora. So with the co-writers, they all and the publishers, they're getting paid from their PRO, so ASCAP or BMI, etc. Half is going to the publishers, half is going to the writers based upon their split of the song. And the song will add up to 100%, and the writers have to divvy it up to get to 100%. And each of the writers' share has a corresponding publisher share. So the song side will get paid out half to the publishers, half to the writers. And from the publisher share, if a writer is under that publisher, if it's a third-party publisher, then the publisher will pay the writer a royalty based on their publishing agreement. And then on the recorded side, for the non-interact sound exchange from the non-interactive stream, will pay out half to the record label, and then half to the artist, and then 45% to the artist, and then 5% to the backing musician singers. And then assuming the artist did a letter direction, the producer will share roughly 15 to 25% out of that 45% that goes to the artist. So that was a lot of kind of hypothetical numbers. Maybe next time we'll actually have a slide up with specific examples, taking the percentages from $1 and what that is, but that's the general flow. Who's responsible for listing session musicians? AFM SAG-AFTRA deals with that 5% share. And they have an unclaimed royalty portal where you can search, do they have royalties for you? The record label should be submitting, have liner notes and have evidence and metadata of who performed on what, so that AFM SAG-AFTRA can verify, yeah, you were a backing singer. You weren't in the band, but you were a backing singer. So here's the share. Note of caution, AFM SAG-AFTRA definitely typically pays out for larger tracks. So if it's a smaller performing track, they don't really pay out too much. If any, it's very small. And someone had a comment before, if you have 300 plays, this is all meaningless. Like, it starts somewhere, and there's a principle of collecting your money. It's just the more streams, the more money there is. And if even on a interactive stream, there may be some money, at least from Apple now, coming in. Even if it's small, the principle of collecting the money that's due is important. But that comment is correct, that it takes quite a bit of streams to be making real money. Would Dolly not get paid as a song? Yes, she would also get paid as a songwriter, but not from Sound Exchange. Dolly would get paid as a songwriter from her PRO and from her publisher. But Sound Exchange would not pay Dolly anything for Whitney's song because Dolly did not perform on it or own that recording. Go ahead, Alexandra.
Oh, no, you beat me to it. I was going to say that same thing and take it back to the Whitney Dolly examples. So we saw that coming at the same time.
Good. Why don't we keep it rolling here, get into physical next. All right, our old classic here, physical. I guess vinyl is going up though. Hopefully things start to get simpler now as we roll through. Physical shouldn't be too difficult. So again, there's selling a CD, selling a vinyl. There's a cost. The record label gets that money for making the copy and redistribution or distribution of the recording. If it's a self-release artist, they get all that money. If it's a record label, they get the money and then pay out the artist. And then out of the artist share, the producer, typically based upon the artist agreement with the label, and whether they've recouped or not. And then on the song, what's the next slide? On the song side, there's a mechanical royalty that's paid to the publisher, which is right now 12.4 cents, or 2.38 cents per minute. So when we thought of like physical downloads for 99 cents, this was easy. Or you think you're selling a $10 CD, each track is 12.4 cents is on the mechanical side. Typically that's paid through Harry Fox Agency in America, unless the publisher has a direct agreement with the label. And then that 12.4 cents goes to the publisher. Nothing goes to the writer unless the writer is their own publisher, and then the publisher pays the writer based upon their publishing agreements. So it's a cent rate here, which is very different than the percentage rates or more complex formulas on streaming. It was 9.1 cents forever. Most of my career was 9.1 cents. So this was a nice improvement. And there's a copyright royalty board, and it improves based on annual rate adjustments and things like that. So that's kind of the physical area is a lot easier to determine how much money is getting made. Someone buys the vinyl for a certain price, and the cost goes to the label, and the label then pays this 12.4 cents to HFA, who then takes a cut and then pays the publisher. There's nuances in an artist agreement. There may be control composition clauses where they reduce their mechanicals to 75% for physical, and though we can't reduce that for digital. And there may be caps. An artist may agree no more than 10 tracks to pay out on mechanicals per album. So if you have a 15-track album, they may get less mechanicals. So there's different contractual mechanisms when an artist is writing their songs to under a label deal, or if a producer or writer has to be bound by those control composition clauses in a label deal, they could get their mechanicals reduced a little bit. But it's an important source of revenue. In other countries, there's typically a society that handles mechanicals. We do it. HFA is kind of our society in America. And that's the gist of physical. Kyoko, excuse me on the pronunciation. If we find if the correct rights holder for 12.4 cents, do we still need to go through HFA? You don't have to. You can always do a direct deal with the publisher, or if you're your own publisher, you just keep your money. You don't need to have it be paid to HFA and then back to you. It just depends if you, as a writer, publisher, if a third party is releasing your music, you either want to get your mechanicals for physical, because the digital is coming through the MLC now. So the physical, the label's collecting the money, and you want to be able to get your 12.4 cents or whatever your reduced rate is, either direct from the label or using HFA as an intermediary.
A couple other questions just to quickly touch on here. So someone asked, how come Harry Fox wasn't listed on the initial MLC diagram? Great question. It's because that MLC diagram was just for digital. So when we're talking about Harry Fox Agency, we're talking about physical. That answers someone else's question as well. They said, where is the song being played to earn these particular royalties? This, we're talking about the physical side of things, or the permanent downloads. So think like old school iTunes buying things for 99 cents, or think going to Target to buy the CD or the vinyl. That's what we're talking about here, the more physical side of things. So that's why it wasn't on the MLC's slide that we showed you earlier.
So we're running tight on time here for questions at the end. We got to get through theater movies and YouTube, our favorites.
Yes.
Right.
Yeah. So let's dive into TV and theater. I know that some people had questions earlier. They were asking about sync, or they were asking about video. So this is a great time for that. When we're talking about sync, or we're talking about a sync license, we are talking about now an audio visual component. So once your song is put with some visual, that's going to require a synchronization and master use license. When we're talking about synchronization, when we say a sync license, that's technically for the song side, and a master use license is technically for the master side, the sound recording copyright. However, in the industry, a lot of people just kind of use them interchangeably. So if you hear someone say like a sync license, a lot of times it kind of just couches both. But just so you know the terminology, they are separate and they are different. Generally, when we're talking about sync licenses, you're going to get an upfront fee. And the upfront fee is generally split 50% goes to the label or to the owner of the sound recording copyright, and 50% would go to the publisher or the owner of the song copyright. So that's going to be your front end. So let's say Nike came up to you and said, hey, love your song, want to use it in a commercial. I'm going to give you $1,000, $1,000 total. Great. $500 goes for the sound recording. $500 goes for the song. But then
let's hope Nike pays more than $1,000.
As I said it, I'm like, crap, that's kind of a low number, but it works with easy math here.
And that 50-50 is not set by law, right? That's just a custom market, good, hands length negotiation. And that's what the custom is in the industry. The labels and publishers all kind of agree, we're going to split this money 50-50 as a market rate, as a negotiated voluntary custom.
Exactly. Yeah, that's completely negotiable, but that is the custom is 50/50. Also, the rate I threw out $1,000. That's also just negotiable. There's a lot of different factors that go into it, just depending on what it's actually being used for, the extent of the music being used, the size of the artist, lots of different factors, but all very much negotiable. And unlike some of the other services we mentioned earlier, where it's like, hey, you have to sign up for it, things are being paid out. For sync and master use, there's nowhere to sign up for initially unless you really wanted to do a sync agent. And there are multiple different sync agents out there who are able to help shop your music around for these deals. But a lot of it is just negotiable. So on the front end, we talked about that flat fee. On the back end, generally, you're still going to be getting those public performance royalties. Again, if it's being played on television or in a film, that's a public performance. And that is 100% collected by the publisher. And the way that they track that is through cue sheets. Generally, you would have to have a cue sheet that really identifies the song. It identifies kind of the writer and publisher, how it's being used, the duration of it, and all of that's tracked through your PRO, so ASCAP BMI, so that way you can get paid those public performance royalties on the back end.
And there, if it's performed in a theater, is there any performance monies there, Alexandra?
Not for a theater in the United States, no.
Yeah, it's a nice little wrinkle. Sarcasm intended, guys, that there's no performance right for theaters. There's an old case there. And then this also doesn't include a soundtrack album. A soundtrack album would go back into the Spotify interactive streaming world. So there's a back end money there on both sides, recording and song. It's being played on Netflix now. Netflix is paying the PROs, BMI, ASCAP, a blanket license. And then ASCAP and BMI are paying out to the publishers. And then, part of the rationale of labels not getting on the back here is they're getting some promotion. Same thing on FM, but if the laws were to change, then there would be a back end performance for recordings here as well. And then we got one more to go, which is kind of tied into sync. I know we're going fast here at the end. So YouTube is an elephant in the room sometimes. So I'll just jump off really high level with YouTube, kind of 3 different buckets, mostly 2. Is you upload music on your channel. So that's like watch page monetization. YouTube typically pays out 55%. You have to hit certain thresholds before they'll enable you to monetize. Maybe Spotify's picking up on that now with their new model. You have to get certain subscribers, watch hours, and then once you start monetizing your channel, assuming you own all of your content, YouTube pays you out roughly 55%. The second, and with shorts, they're paying out 45%. And then there's also kind of other commerce products where YouTube's paying out 70%. Let's go to the next slide. The next one is really the second bucket is somebody else uploads your content. They're doing a cover of your song, or they're dancing to your recording, which is both your song and your recording. So YouTube has a system called Content ID. If you have enough subscribers, you can have your own account, or typically you would use a vendor, or your label or your publisher will have a Content ID account or vendor. So if somebody else uploads that cover song, hopefully Content ID tags it, or you can claim it and say, hey, someone else is playing your song. Do you want to block it? Or do you want to claim it and monetize it? So as the owner of the copyright, you get to decide if you want something taken down or if you want to monetize. If it is a recording, it's typically split around 35% for the recorded side, 15% for the publishing side. If it's a cover, that's all going to the song side because there's no pre-existing recording getting used. If there's multiple publishers or labels, they have to all opt in and choose to monetize to get to 100% for it to actually get monetized. So that YouTube's a big place where a lot of music's being performed, and it's important to kind of see how that money flows. And again, if it's going to the publisher here, it's considered sync money. So it all go to the publisher and then they pay out to the writer. There's also performance monies from YouTube that YouTube is paying the PROs a blanket license. So there's technically the songwriter publisher shares from the performance that's coming out of YouTube as well. So YouTube kind of sees a lot of different areas of our discussion here. This is why we put it at the end. Hopefully this slide doesn't do it justice, but our intent was to kind of tie it all together. with all these different concepts. We got 5 minutes left. Let's do some fire questions here. What do we got? What do we look in the Q&A, Alexandra? That looks good here. And while
Yes.
we do that, here's our contact info, everyone. We're going to do our best to get this webinar up. I know we were talking fast. I know there's a lot of questions that we didn't get to again, and anybody that's got specific cases about infringement or registering your works, like, hit us up, contact us. We can see if we can help, if at all possible. We love doing this. We love helping music professionals, whoever you are. We work with writers and producers and labels and apps and everybody in between to ensure that rights are being protected and money's being collected. What questions we got, Alexander, in our remaining few minutes here we want to get at?
Yeah, so just a quick, simple one, kind of tying it back to Content ID. Someone asked, how do you get a Content ID account? So that one, YouTube has Content ID where you can try and do it through your YouTube profile, but you have to be at a certain level before you're really able to do that. And that's not always feasible for beginner artists. So there are some third-party companies that can help you with Content ID if you're interested. I believe 2 of them are like Audium and AdRev. I'm sure there's a lot of other ones as well. But there are some third-party accounts that you can sign up for if you're interested in trying to really monetize and monitor your YouTube accounts to make sure that people aren't using your works. There were a lot of great questions here as well, just kind of about hiring an attorney. So I want to make sure that we get to those before we leave here today, but also just want to make sure that we answer some of the other more substantive or more high-level questions as well that specifically relate to the royalties here. But while we kind of search through that, so there were a couple of questions about just hiring an attorney that I want to make sure that we get to. Number one, like, are we taking on new clients? Yes, we are here. We're taking on new clients. Feel free to reach out to us and let us know if you are actually interested in working together. If you have any questions that we didn't get to today, we're always happy to chat. I know there was another question about, do we only do California law, or kind of where can you find an attorney that's licensed in your state? So we are California attorneys, and we primarily provide advice on California law, and we can do kind of federal law, copyrights and trademarks. But the good thing with music is that a lot of these things are based on kind of that federal law system of copyrights and trademarks. So it is very similar across the United States. So we do represent clients both in California, throughout the United States, and worldwide. So generally not an issue, but of course there are some concerns that do come up. So if you ever have a question about that specifically, let us know.
Well, I'm going to jump off the question. Based on
Yes.
everything we covered today, Alan's question, what's the best path to get paid the most money in the music industry? Someone replied, hold on to your publishing rights, agreed. If you can keep your copyrights, amazing. Something else, just practical advice, is to be organized with your metadata, know your track names, your release dates. Like, each release on the recorded side will have an ISRC, International Standard Recording Code. That's how Spotify and Apple Music will track each play to pay out. The song side will have an ISWC, which the PROs will generate once the song is registered. Have your splits in order, and so that you know your co-writers, so that and their publishers, so if there's a film opportunity, you're not scrambling to figure out who has what part of the song. You're ready to rock. Let's license. Let's figure out the right quote and the right terms. Let's get paid. It's in the cue sheet. It's all registered. So now it's getting played on Netflix, and you're getting your money, and you're organized with your data, and ideally you have a good team around you helping you. You can talk to your lawyer, your label, your publisher, your manager, to kind of all help work together to ensure that everything is getting registered and tracked and collected appropriately. At a bigger level, you'll start to have companies in each territory, sub-publishers or foreign collection agents, to have feet on the ground collecting in different countries that know the people there. But it all starts with the song and a good recording of that song, and then being organized, having things registered timely, so that you're collecting all the different sources of revenue that are deserved from your music.
Yeah, and you know what? I think that was a great way to wrap it up here. I think that was like a great last question to kind of tie everything together. So I think Rachel's going to close us out here, but I just wanted to say thank you so much, everyone, for coming today. I know that we didn't get to all the questions, but again, just feel free to contact us. But you all have been very interactive and great, and I definitely thoroughly enjoyed being here and being able to help hopefully give you more information to really start to protect and monetize off your music more.
Awesome. Thanks so much, Alexandria and Jesse. This was like drinking from a fire hose, really. And I think I learned a couple things myself as well through the webinar. So really, thank you again so much for your time and expertise and just walking us through sort of the music royalties landscape. As we mentioned in some of the Q&A questions that came up about whether or not there will be a recording available, there will be a recording made available after the event, so stay tuned for that. And again, you know where to find Music Law Pro. Their information is on the screen, and then also encourage you to continue staying on top of these issues, learning more about these issues with the Copyright Alliance by signing up for a free creator membership on copyrightalliance.org. And with that, we'll conclude the webinar, and we will see you all for whatever next we have in store. All right, thank you all.
Thank you.